gonna backtrack. And you should've kept my name out your mouth. That's though how it all turned out. When you try to use my name for clout, keep on going, give me something you can talk about.
Hello, everybody. How are you doing this fine Thursday, July 10th at 3:52 p.m. So, yeah, all right. So we're still all kind of collectively coming back together, getting our bearings, as they say, in reference to this Sean P. Diddy Puff Daddy Combs trial. It's now over. We are waiting for sentencing, which is scheduled to happen on October 3rd. Something's tickling my throat. Okay. So, in the meantime, a bunch of stuff has happened in other cases, and I thought that we could take this opportunity today on today's live stream to catch up with some of those cases that I have covered in the past and cases that I've covered in the past and have some updates to discuss. So, let's start with yesterday. Yesterday, there was a case update, a hearing of sorts in that Shannon Sharpe lawsuit. Remember the Jane Doe, and it was like Tony Busby was representing her, and it was right after that Bree Stern case came out with Andrew Tate. It happened all in the middle of all of that. Yeah, maybe it's the pollen falling because I did go outside earlier before I came on live. I've spent basically all day today. I'm basically seeing stars. It's like almost 4 p.m. But I've been awake since, I don't know, 5. I did a live stream this morning. It feels like days ago. It was like a get ready with me, members only this morning. So basically since then I've been working. Did some planning for BJ Investigates. Got a few things together for some recording. I was going to record today for BJ Investigates. I didn't end up doing that, so I'm going to have to do it tomorrow. And then after I finished that planning meeting, I jumped into trying to catch up on all these different lawsuits. What's coming up? What did we miss? I think they're sharing the membership link in the sorry, excuse me. I think they're sharing the membership link in the live chat right now. So yesterday we had a Shannon Sharpe update. Some of these updates are going to take a little bit longer than others. This one I think will be pretty short, but let me pull up this is an article we're going to read from newsnow.com. Live Local Now is what it says at the top. Okay. Attorneys, this is from yesterday. Today's July 10th, and this is from July 9th. Attorney for Shannon Sharpe's accuser, so that would be Tony Busby and another guy whose name Cash or Nash or something. This is an article from yesterday. Attorney for Shannon Sharpe's accuser, a no-show in court for first hearing. The first hearing in the lawsuit against Shannon Sharpe took place yesterday, Wednesday, in downtown Las Vegas. A woman filed the anonymous lawsuit suing the Pro Football Hall of Famer for $50 million, accusing him of assault and battery. However, no attorneys showed up on her behalf for the first hearing. Clark County District Court Judge Anna Albertson expressed her disappointment in court that no legal representation was present for Jane Doe. Now, remember, this Jane Doe has been outed as Gabriella Zuniga, something like that. And Shannon Sharpe put her name out there. And then there's also, Busby came out and admonished Shannon Sharpe and his team for saying Jane Doe's name. So yesterday, no lawyer bothered to show up on the plaintiff's side, like the person suing Jane Doe. Nobody bothered to show up for her. And she is represented by Tony Busby. So Shannon Sharpe, his lawyers showed up. Excuse me. his lawyer, at least one of them, at least somebody showed up to represent him, but not Jane Doe. She filed the anonymous lawsuit accusing him, suing him, for $50 million, accusing him of assault and battery. No attorney showed up on her behalf for the first hearing. The judge, Anna Albertson, expressed her disappointment in court that no legal representation was present for the person who sued. Robert Draskovich, a criminal attorney in Nevada who is not a representative on this case, so they just polled a lawyer friend. He called this move of Busby and his co-counsel not to appear, quote, strange, and not in the accuser's best interest. Whether to set up a settlement conference or to set hearings for litigation, you would expect all parties to be present. I can't see a tactical advantage to be gained by failing to appear. And that is what this lawyer said. Now, for his, for Shannon Sharpe's team, it's like I breathed in something fuzzy, like, man. So for Shannon Sharpe's team, one representative, attorney Robert DeMarco, appeared in court on Shannon Sharpe's behalf. His lawyer said the other attorneys on the case that were co-counsel with the defense with him were busy with other cases out of state at the moment. Shannon Sharpe's legal team is mainly composed of lawyers from New York. Okay, so they're mostly lawyers from out of state. They didn't fly in for this hearing. They had Robert DeMarco. That's Shannon Sharpe's side. Now, this legal expert that they polled over there at 8newsnow.com, I might have previously said, I just want to make an amendment. I might have previously said this was newsnow.com. That's not true. This is 8, the number 8, newsnow.com. So they polled this lawyer. They interviewed this lawyer, Robert Draskovich. He shared the personal perspective that it is not the best move to have legal representation from out of state because the civil lawsuit was filed in Clark County, Nevada. This is a quote from that lawyer, quote, generally, it's better to have homegrown counsel, he told 8 News Now, explaining that there are intricacies in our system that a Nevada-based lawyer would understand best. Quote, if you have a matter pending in Nevada, it's best to have Nevada counsel. Now, Shannon Sharpe's team asked the judge to review the progress of the case at a later date. So the judge was surprised that Shannon Sharpe's team did this. She expressed surprise that his team did not want to settle this case sooner. Now, I don't know why they use the word settle, if they mean specifically like in the legal context, settle the lawsuit, or if it meant just like the judge expressed surprise or concern that Shannon Sharpe wasn't trying to get this over with before then. I'm not exactly sure because these documents, perhaps they are available to the public, but I looked high and low and I can't find them. So if y'all know how to get a hold of these documents for like, even just the documents, wait, hold on. I think I can get the documents. It's the transcripts, I believe. No, Nevada, no. I can't. I'm having a hard time getting the documents. So as you could see from the thumbnail and as you will see in this video, I did in the past several hours catch up on many, many lawsuits in different jurisdictions. So as we read through, you will be able to see and cross-reference things that I'm saying. This is just a live stream. I'm just kind of going over like a stream of consciousness. Please don't take anything that I'm saying as if it's a fact. Everything I'm saying is from these publicly sourced documents, and I might accidentally say something that mix matches with this on the screen. My purpose here is not reporting on the news. My purpose is just kind of doing a roundup, showing you what I found, trying to synthesize it. I do the very best I can not to make mistakes, but you know, sometimes I do like say the wrong thing and it's like, oh God, I'll be listening back to something I said to myself, like in a video or whatever. And it's like, Oh, that's not what I meant. So just to, I do have these disclaimers all over the place, but only not only for legal liability, but also for just like so everybody understands the context of what's going on here, that y'all don't think this is something that it's not. This is not a news show. This is not the facts hour. Okay. I'm doing my best to bring you the facts. There's a lot of times like here where we don't have the documents, we don't have the transcripts. And so whenever there's not a fact available, I will insert my opinion. I'll insert a speculation. I'll insert some different possibilities. I do try to do my best to let y'all know whenever it's my opinion, but just so that you are aware, I have not read the transcripts. I have not been to the court for any of this, but I'm getting the cases kind of mixed up because we are going to talk about another case in Las Vegas, Clark County, and that's going to be the Kefi D case. That's we're going to talk about that on this live as well. It's one of the cases we're going to catch up on. So that one's also in Nevada. And again, y'all, I'm doing this all top of my head. Even that just now, maybe it's a different, I think it is Clark County, but you'll see why it's a little confusing. But I'm going to show y'all court documents. I'm going to show y'all public filings, stuff like that. So buckle up, get a snack. We're going to go through a few different things as we go down the list. Okay. So also, if you keep a calendar, might be a good time to get your calendar in your app, whatever you do, because I'm going to go over some key important dates on these trials, on these cases. Some are criminal, some are civil, some are hearings, some are filings. So I'm going to be going over some critical dates in some of these cases just to give y'all a heads up. In a few minutes, you might want to put some of these dates in your calendar. All right. So right now we are talking about Shannon Sharpe. This is a former Super Bowl champion. He's a football player, or he was, retired. Now he has a very successful podcast. He does the Nightcap series with Chad Ochocinco. He does that with him, and he was on ESPN, but then he got this lawsuit filed against him. A Busby suit, a Busby special. He got this lawsuit filed against him back in, I believe it was October. When was it filed? I think it was earlier this year. I don't know off the top of my head. I don't want to give dates, and I'm just like so totally wrong. So I'm not even going to speculate. But yesterday they had a hearing. In fact, it was the first hearing of the whole case. And Busby announced yesterday also that he's going to be starting a podcast, and he was announcing that he was looking for sponsors. He was looking for products to review. So while he was, having that posted on his Instagram, there was a whole hearing over here in Nevada. Somebody missed it. Okay. Nobody was here. First one, it was yesterday. Now they're interviewing this lawyer who's just giving his opinion on the case. He says it's better to have somebody from Nevada. But surprisingly, Shannon Sharpe just kind of like allowed this to go on. And there's one other issue or one other point that I want to bring to your attention about the Shannon Sharpe lawsuit. And that is that in most jurisdictions, you have about 30 days to respond to a complaint for the specific allegations that Jane Doe makes against Shannon Sharpe in her lawsuit. Well, that 30 days done came and went. It's done come and passed, and it's gone now. It's bye-bye. And Shannon Sharpe never filed a response. Now, also, if you remember, a third point of contention that I want to bring to your attention, that wasn't a rhyme on purpose, is that, hold on, I was looking at y'all's comments. I got distracted. Hold on. Third point of contention is that Busby, got it. All right. So Shannon Sharpe's lawyer had come out publicly and said they were going to file a counter suit. Remember that he was going to do a counter lawsuit for defamation, and we're going to sue the lawyer too. Well, that lawsuit never got filed yet. And I do think they have, still time to file it, but that lawsuit still has not been filed. So not only has that lawsuit not been filed as was promised to be filed, I mean, people can change their mind. That's fine. No problem. But then when you put that together with the fact that Shannon Sharpe wasn't responsive to this lawsuit yet, he hasn't filed a response. He hasn't filed a response. And then, nevertheless, his lawyers showed up to represent him in court yesterday, which can't be said for Gabriella Zuniga, aka Jane Doe's lawyer, who is Tony Busby. All right. And when the web goes round and around and the web goes all around, you know? Okay. So the next hearing on that particular case, they have a check-in on August 22nd. If you got your notebook out, that's next month, about 6 weeks from now. Again, that is Clark County, the 8th Judicial District Court of Clark County. And then just about a week or two later, on September 3rd, we're going to have, and this will be the last update for him until we move, before we move to the next category of, the next person's cases or whatever. But then, so that's August 22nd. He's going to have the status check. I don't know if that's an in-person court hearing or what, but it's 3 p.m. local time, August 22nd, if y'all are keeping track of that. 8th Judicial District Court of Clark County, Nevada. It's August 22nd. Okay. Then just a week or two after that, about almost 2 weeks after that, September 3rd, there's another hearing. Now, this is a mandatory Rule 16 conference. That one's going to be at 11:15 a.m. local time in the 8th Judicial District Court for Clark County. This is, again, Jane Doe versus Shannon Sharpe. Okay, so that is what we had for that particular category of cases. Shout out to Down the Rabbit Hole News, renewing that membership. Thank you so much, R. Har, becoming a member. Okay, so Shannon Sharpe, check, done. We're done with that one. Moving on to the next cases. I'm going to go in calendar order because I have this stuff listed in calendar order. So I'm going to go in Drew Dixon versus Russell Simmons. Drew Dixon versus Russell Simmons. Drew Dixon is a music industry powerhouse. One of the, big groundbreaking glass ceiling shattering icons of the music industry for women of color in particular, but women altogether. She was just early and powerful and prolific in the music industry. Okay. She worked at Def Jam. She worked at Arista. She worked with all these people, right? Well, she got a couple lawsuits going on. You might have heard at some point in the last year or two that Russell Simmons was able to get out of a lawsuit or jurisdiction for a lawsuit because he was able to prove that he lives in Bali or something. That was this lawsuit. And you might also or otherwise have heard that Oprah Winfrey was getting dragged in to Russell Simmons' legal troubles. There was an Oprah Winfrey comment made by Russell Simmons, and then maybe a comment made by Oprah about some documentary. They did a kind of like a Me Too moment, like a surviving Russell Simmons moment in a form of a documentary. And things were said. Years go by, and then Russell Simmons comes, or sometime, I don't even know if it's years, but some time goes by, and Russell Simmons then does an interview himself. He does an interview where he makes some statements about some of his accusers. Now, one of his accusers was, I'm doing this off the top of my head. I might be getting some of the facts wrong, but just this is for the broad strokes, okay? The broad strokes. There was a documentary. Oprah was allegedly supposed to be involved in producing the documentary. She pulls out the project. She decides she can't do it. Something about alleged victim witness credibility issues from the documentary. But then Oprah kind of wish-washes. She kind of doesn't give a fully consistent public answer as to why exactly she did pull out of this documentary. And then, of course, the documentary series comes out. Drew Dixon's one of the accusers. There's a lot of Dixons, too, in these lawsuits lately. There's the Terrence Dixon that is suing Fat Joe. There's another, is it Terrence? T.A. Dixon. And then there's another Dixon suing Tyler Perry. This is not those lawsuits. This is Drew Dixon versus Russell Simmons, not to be confused with Drew Dixon, same Drew Dixon in this case, versus L.A. Reid, which we're also going to discuss today. But right now we're talking about Russell Simmons. Now, I did make a video about this. Let me show y'all the video actually on BJ Investigates. If you want to re-familiarize yourself with the Drew Dixon versus Russell Simmons lawsuit, it's crazy, y'all. It is crazy. Okay, this is the video right here. This is it at the top right here. It's Oprah, Russell Simmons, and the Cursed documentary. Full story, okay? It came out 2 months ago. Let me put the link in the chat for y'all. If you want to go back and re-familiarize yourself with what's going on in that lawsuit, this is Drew Dixon versus Russell Simmons. Now, in that lawsuit, she makes a series of very, excuse me. So there's a couple lawsuits back and forth. Okay. So there's like lawsuits in the federal court, lawsuits in the state court. Some have been dismissed. Some are allowed to keep going. There's also, a defamation lawsuit. So Drew Dixon is not only suing, and again, y'all, it was 2 months ago I went over this, so it's kind of like blurry now, but I'm going to pull up, don't worry, I'm going to pull up a document in a minute, and you want to take my word for it anymore, but I'm just kind of like, if you haven't already heard this stuff, just giving you enough to like kind of get on the wagon of what we're about to look at, just so you're kind of like, okay, yeah, there's like, it's like a big deal in the music industry. Russell Simmons, he's the Def Jam, one of the Def Jam guys. Is Leor Cohen also Def Jam? Somebody put a Leor Cohen in the chat. If he is, am I making that up? Yeah, I put the link in there. Right here. So, shout out to Helen. She got a gift membership. Okay, so there's a documentary. The documentary is kind of at the heart of the first lawsuit. But then Drew Dixon sues for like, I believe, like actual assault. There's all kinds of stuff going on. Okay. So let's zoom in a little closer. Let's zoom in to like the specific lawsuit I want to talk about right now. They got a hearing coming up soon, and that's why I wanted to talk about it. I did make a video on this. I just linked the video in there if y'all want to check in on that later. I need to hide y'all's comments because I get distracted. Okay. So there's a documentary, the Oprah thing, all that. And you might have seen, Oprah was subpoenaed. Oprah subpoenaed and Russell Simmons lawsuit. Yep. That's the same lawsuit, trilogy, progeny, whatever you want to call it. So in this particular one that they have a hearing coming up for, it is the craziest, wildest story. All right. So you might already know the story. I'm going to tell it again from memory. So it might have some little details wrong, but Drew Dixon sued Russell Simmons for defamation. Why? Well, because Russell Simmons went on this Graham Bessinger, whoever it is, and he made some statements about his accusers. Which accusers? The ones from that documentary. See how it all kind of like is in the same universe? So he's on this podcast. Russell Simmons is on a podcast, and he's answering questions in an interview style about allegations, accusations, and it's kind of like his kind of clearing the record moment from those allegations, accusations that had been being made. Let me see if I can get a picture so y'all can get a visual. Russell Simmons, Graham, what is his name? Bensinger. Now this guy likes a copyright strike, so I ain't gonna play it. But this is the This is that interview, okay? So in this interview, he's saying some stuff, all right? He's saying, I had relations with all kinds of women in my life. And it's like, 6 of them has a problem and an issue? I mean, I've had thousands of relations. This is from 1 year ago. Interesting. Members first. So he said some stuff in this interview. So then Drew Dixon sues him for defamation. Well, instead of responding to the substance of the defamation claim, which is totally appropriate and totally normal. Oh, did I share this with you? Yeah, I showed y'all that, right? That's the interview. That was from a year ago. So, there was also another interview that I think has something to do with this, which is like he was on Zoom. Again, I have a whole video about this already. Please don't take my word for it right now. Like, go watch that video if you want all the details. I'm just trying to get to the update that's about to happen and just catch y'all up for what is absolute need to know to get the gist. So Russell Simmons, in response to this defamation lawsuit from Drew Dixon, Russell Simmons' team files a motion to dismiss. And I think he made fairly strong arguments. Y'all know I'm a little sympathetic to a defamation slap suit because I've been sued wrongfully. So I kind of have a sympathy for the freedom of speech and things like that. So I'm like, we'll see. It wasn't like a total loser dead in the water argument on the motion to dismiss. He had an argument, so it's kind of like, all right, cool. Let's see if the judge is going to dismiss any of these claims, any statements, because, it's like different statements. That's grounds upon which the defamation claim is based or whatever. So remember, it's Drew Dixon that has sued Russell Simmons. Now, they've already been tussling in the courts already by this point. Okay, this is maybe their third lawsuit or so that they've had between the two of them. So the one we're talking about is defamation. And Drew Dixon sues Russell Simmons, and Russell Simmons files a motion to dismiss, much like I did in the Lima lawsuit. Okay, but unlike in the Lima lawsuit, in Russell Simmons's and Drew Dixon's defamation lawsuit, this was not in New Jersey, which is where mine is. There's in New York. And the judge called for oral arguments to occur. The judge wanted them to come argue. The judge wanted to ask questions, maybe. The judge wanted to get a sense of what these sides' arguments were. Tell me why Russell Simmons' side, his lawyers, just literally, deja vu from the first case we talked about, the Shannon Sharpe one, Russell Simmons' lawyers, the ones who called for this motion to dismiss, the ones who wanted the judge to dismiss the lawsuit, they didn't show up. They didn't show up for oral arguments. They didn't show up. Russell Simmons' lawyers didn't show up. Let me bring up some of the documents. Like, there's a letter that's like a whoopsie that Russell Simmons' lawyers hold on. Sorry. Let me find I have the folder open. I just have to find the exact right document. Wait, there's a transcript of the hearing? Yeah, okay, there's a transcript of the hearing. Let's start there. Let's start with the transcript. Y'all have somewhere to be? Y'all have somewhere to be? Or can we look at the transcript? Okay. These are public records, by the way. Also, please do not contact anyone mentioned in this live stream or any of my live streams. That is not the purpose. Purpose of my live streams is to read and comment and provide opinions and perhaps a little education from time to time on matters of public concern. Right as I'm saying that, I'm realizing I need to do some redacting. Hold on. Let me redact some Let me redact some address stuff. Okay. So this is, again, what are we talking about? The second group. Don't trip. I said it said, gotta be right here. Shout out to you. So yeah, they didn't show up, and we will read the few little sets of documents just because it's a live stream. It's fun. We'll just do it. Oh, hold on. This isn't what I wanted to have up here. Let me pull up the document. Okay, here it is. Now, this is a public document. Drew Dixon versus Russell Wendell Simmons. Okay, so that's what we're talking about. We're talking about Drew Dixon versus Russell Simmons. Now, don't get this confused with the Drew Dixon versus LA Reid, because we're going to be talking about that one in a little while as well. Okay, we're not talking about that right now, though. We're talking about Drew Dixon versus, do y'all know what she looks like? She's the lady that I put in the thumbnail in the middle. That may be a more like outdated picture or whatever. However, that is her. Okay, so that's her. She's, again, like I said, a big deal in the music industry. And beside from that, she did something I never could do. And I can't say that about a lot of people. She got into Harvard. Yes, she did. Now, I did not apply to the business school, but she went to Harvard Business School. She went to Harvard Business School. Now, we've already talked about this. I think I covered it on this channel as well. But she is very accomplished. Very accomplished. Okay, so this is the transcript. It's only 3 pages long. The court says, counsel, appearances for the record. Yes, Your Honor. Kenya Davis for Drew Dixon. Okay, so who's Kenya Davis? Kenya Davis is Drew Dixon's lawyer in this case, suing Russell Simmons. Along with my colleagues. So then not only did they show up, but, she showed up, but Daniel Crispino and Max Hyams also showed up. Okay, so they're all here. They're up front and center. They're ready. Okay, who's here for Drew Dixon? Kenya Davis, Daniel Crispino, and Max Hyams. The judge said, all right, cool. The court had this matter for 2:00. There was no appearance by Russell Simmons's lawyers. And he's the movant, right? The movant means like he dragged us all out of bed. He dragged us all here. And where is he? The court called Russell Simmons's lawyer's office. The judge, imagine the judge on the phone calling your lawyer like, hey, you going to come to court or like what? The judge is talking. This is a transcript. It was a secretary. A secretary answered. You imagine the judge is calling and it's a secretary. Oh, hey, hi, yes, can I speak to, hold on. Hello, Russell Simmons. Russell Simmons's, lawyer's office. Hi, hello, can I help you? Yeah, it's the judge. Like, what the hell? Like, aren't you supposed to be in court? Like, why? Oh my God, I can't believe, okay. Just imagine it. The lawyer don't even answer. Okay. This is my judge phone. Okay. I had to do that one in the moment. Saturday Night Live could never. Okay. A secretary answered. Now imagine you're Russell Simmons. You're paying all this money and your lawyers don't even show up to court. Now I know some people are saying, oh, it was a delay tactic, but I mean, I don't know, y'all. He had a pretty fair argument. On the motion to dismiss. I don't think he would just be playing around on this one. It was a secretary that answered. The judge said, I explained to the secretary the fact that the matter was scheduled for oral argument. Like they had oral arguments. Like everybody came here to have an argument. Like it was supposed to be his side, their side, and we're going to argue over whether to dismiss Drew Dixon's defamation complaint against Russell Simmons. The judge said a message was taken. And you know how they have to like blow smoke up the judge's behind, like Your Honor, thy honor, thy highness. You know what I mean? Like you didn't even answer. The judge had to even call you, first of all. But second of all, whenever he did, you didn't answer. You had the secretary take a message. Oh my God. Ooh, that's $100,000 out your pocket after you have to file for all that. To fix it rather. So I'm like, hey, it's scheduled for oral argument. A message was taken. The judge said, I mentioned the fact the court would hold this matter until 3:15. So it was scheduled for 2. But the judge said, I'll hold my schedule until 3:15. This is after the court attempted to contact them at 3:00. The judge says it is now 3:18 and there is still no appearance. Also, no phone call to the courtroom with regard to the appearance. As such, the judge said, the motion to dismiss is denied. Now, who filed that motion to dismiss? Russell. Russell Simmons. So Russell Simmons' motion to dismiss is denied because his lawyers did not bother to show up to court. It was like 2:00 scheduled. The judge is calling. The secretary answers. He leaves a message. He holds the calendar until 1 hour and 15 minutes. He even waited 3 more extra minutes. Nobody called. Nobody appeared. So no, your motion to dismiss is denied. You didn't bother showing up. Russell Simmons has 20 days to file an answer. Motion to dismiss denied. Then Drew Dixon's lawyer speaks up and says, if I may, Your Honor, the defense, that's Russell Simmons, raised in their motion an anti-SLAPP case, and we would ask that the stay that's been put on discovery be lifted. Okay, good point. In most jurisdictions, in all the ones I know about that have anti-SLAPP statutes, and I think there should be a federal anti-SLAPP personally, some things happen whenever the defendant says this is anti-SLAPP. Now, remember when I told y'all that Russell Simmons had, not the worst arguments ever? He could have actually got maybe some of these statements dismissed as non-actionable opinion. One of his arguments is that it was free speech and it was protected by the First Amendment because it was his opinion or whatever. It's a few different statements, right? But just on one of them, he's like, this free speech, and therefore this lawsuit is subject to the anti-SLAPP statute. Drew Dixon should have to pay my lawyer's fees and all that, right? Motion to dismiss. Well, the day he was supposed to show up and argue that, he didn't. His lawyers were supposed to show up and argue that, and they didn't. So, poof, motion denied. No more anti-SLAPP on the table. Goodbye. Well, as a result, Drew Dixon's lawyer is like, all right, so now that's out the window, he has 20 days to file an answer. Can you lift the stay that's been put on discovery? Now, whenever you plead in defense to a defamation claim that you are entitled to protections of the anti-SLAPP statute because it is a First Amendment protected activity, many jurisdictions will place a stay on discovery. So you can't just sue somebody for saying something they're allowed to say and then all of a sudden be able to get in their bank records. No, we gotta just decide first, was this an issue of free speech that they were allowed to say, and it doesn't matter if it hurts your feelings or not? Because if yes, it would be premature to let you all in all their bank accounts and everything, right? So Drew Dixon's lawyer is like, can we lift that stay so I can start getting in their bank accounts and everything? The court said yes. Motion to dismiss being denied by definition means that the stay of discovery is presumed resolved as well. Thank you. So Russell Simmons's lawyers freak out. Freak out. Okay, they send their own letter. Let me find it. Oh, where is it? If I can't find it, I'll have to maybe just... Here it is. I found it. Oh my gosh. So this is the same day. And look at them. Look at them freaking out. So these are the people, hold on. These are the people who missed the court hearing. I'm just covering up address. Even though it's a public address, it's a public document. Y'all know how you know how it is out here. They trying to get us out here for anything and everything out here. So nope, not me. Nope. Okay. So here's them freaking out. Same day, February. This is earlier this year. 5 months ago. We represent Russell Simmons. We write in regard to the oral argument that was today. Look, February 5th. We never received notice. Of this appearance. We deeply regret missing the opportunity to argue our motion. Ooh, how mad are you if you're Russell Simmons? At 2:56, okay, so like an hour after the hearing started. Remember, it started at 2. A receptionist received a call from Your Honor and notified the undersigned there was an appearance that we're tardy for. We immediately checked the docket. We didn't see any scheduled appearance. We took the following steps. So they'd waited like 10 minutes to do anything. We called Your Honor's chambers at 3:04. There was no answer. 10 minutes later, they sat around for 10 minutes and did nothing. We called counsel for plaintiff Daniel Crispino, no answer. At 3:14, we called counsel for Kenya Davis, counsel for plaintiff Kenya Davis, no answer. 1 minute later, we called again. That was their deadline. Remember, 3:15, they were cut off then. We emailed both counsels. We called the clerk's office, spoke with representatives, but they're like an hour and a half late. We called Your Honor again, no answer. We still do not see any notice of this appearance being scheduled. The only place we have been able to find a record of today's conference is on the eCourt's website. But that website doesn't list our correct contact information. They got the wrong contact information. Oh my gosh. We sincerely apologize. We're going to file a motion to re-argue. So they did just that. They did just that. And so all that to say, just coming up in about 5 days, there's going to be an argument. Is it going to be an argument on whether or not to dismiss Drew Dixon's lawsuit? No, it's not. It's going to be an argument on whether or not the judge is going to vacate his judgment. Because what was the judgment he made? Or basically reverse the decision he already made, which was to deny Russell Simmons's motion to dismiss the lawsuit. Now, again, this is the defamation lawsuit from Drew Dixon. So there are more oral arguments coming up on July 15th, 16th. So like 6 days from now. More oral arguments coming up in this case. Now, the first ones we just decided and just discussed, we just discussed and found out or were reminded Russell Simmons' lawyers did not bother to show up for. So hopefully he shows up. Hopefully he shows up. Now, what are they going to be arguing about on the 16th, next Friday? They are going to be arguing over whether or not it was reasonable for Russell Simmons' lawyers to miss that hearing. They're going to be arguing over whether, essentially bottom line, whether or not the judge is going to open up the possibility for them to later come back at a later date and then argue the motion to dismiss, because the door has closed on the motion to dismiss. The judge has closed the door. Russell Simmons' lawyers wants to open the door back up. And their reason is like, because of the eCourt's website. The eCourt's website didn't show us that we had a hearing. We didn't get notice. Now, again, I think that Russell Simmons had a strong argument on some of his points. But then you just disrespect the judge and everybody by just not bothering to show up. And come to find out, Drew Dixon's legal team had traveled all the way from DC. So that is going on with that. Okay. Let's see. Yeah. So it's oral arguments on a motion to vacate a decision or order or judgment or award by the judge. So basically, Russell Simmons wants the motion to dismiss to be able to be argued about. He's like, had good reason for missing the hearing. It was all the website's fault or whatever. Now, the judge could say, yeah, all right, I'll hear your arguments for motion to dismiss and then hear those arguments at a later date. And then still at the later date, still say no, lawsuit moves forward. The judge could also dismiss portions of Drew Dixon's defamation claims, or he could allow all of them to move forward and deny the motion to dismiss, or he could dismiss the lawsuit. But it's not even being argued about yet. They got to argue about whether or not they're going to be allowed to argue about it. And this is all, again, because Russell Simmons' team did not show up to court. They claim they have a good reason. We'll hear about it from court, hopefully. All right. So that's coming up on July 16th. Now, We already talked about August 22nd and September 3rd, which is Shannon Sharpe status update and mandatory Rule 16 conference. That's the 3rd, September 3rd. Then on September 8th, we have another status update hearing for a lawsuit, again, having to do with Drew Dixon, and she is the plaintiff. This one is suing L.A. Reid. Now, I may do a whole separate video reading the L.A. Reid, the Drew Dixon versus L.A. Reid lawsuit, but they do have a status update hearing coming up on September, in about 2 months, on September 8th. Now, something very interesting happened already in this L.A. Reid case. I think Rabbit might have even made a video about it. I have my notes right here. Now, this case, interestingly, involves Sean Chapman Hawley, and I've been hearing that woman's name ever since the Free Britney era, all right, ever since 2020. Sean Chapman Hawley is representing L.A. Reid. Who is L.A. Reid? He is the owner, or excuse me, I don't exactly know, was, whatever. He was the head of LaFace Records at some point. He was the head of Arista Records at some point. I don't know about if he ever was like owner, which ones he started. I think he started and founded LaFace Records, because it's like Babyface, L.A. Reid, and I think somebody else, Clive Davis or somebody. And then he was like CEO or CFO or COO or something of like one of them. That one might have been Arista, but he's a big deal. And he signed Usher. Remember little baby Usher? And he was, what was he singing? Was it Boys to Men? At the top of the Blue Cross Blue Shield building in Atlanta, Lil Usher, he came from Chattanooga, moved to Atlanta. The anti-youth drug group. Remember that? I got a video on that too. Let me pull that up. Let me pull that one up and show y'all. It's this one right here. Usher's twisted rise to fame. This one right here. It's a long one. This one was we worked really hard on that video. See the Clive Davis in the thumbnail? He's in there. So the person who, first signed Usher, it wasn't Sean P. Diddy Puff Daddy Combs. That whole thing about the fighting over the Frosted Flakes at the P. Diddy Puff Daddy flavor camp, he just got sent off over there. I mean, I talk about the whole thing on this video. I just put the link in the live chat. Thank you, Monica. Shout out to the mods in the chat. So, yeah. All right. So, L.A. Reid. So, Drew Dixon is also suing L.A. Reid. Again, we can go over that lawsuit at a later date. I don't want to get into the ins and outs, but it has to do with S assault, S harassment, workplace environment type situation, if you know what I mean, blackballing from the industry type sort of situation. Horrendous allegations. I don't know. I wasn't there, but she done sued him. Okay. And they had a hearing yesterday. Yes, they did. And guess who was in there? Inner City Press. Yes, he was. So status hearing yesterday on that. There was a thing yesterday for Shannon Sharpe. You see how this stuff is just all like just going all at once. So Sean Chapman Hawley is representing L.A. Reid, and she's trying to get out of it. She is trying to not have to represent L.A. Reid anymore, because why? Well, she said there has been a substantial breakdown of the lawyer-client relationship. Let me pull up. Okay, here's a joint status report. Hold on. I'm going to pull up this filing. This is public. There are like public ones, public versions. So this is the public version. I don't have access to any other versions. Docket number 169 in Drew Dixon versus L.A. Reid. Oh, wait. No, this isn't the thing I wanted to pull up. Hold on. This is. See how it says public version right here? Drew Dixon versus L.A. Reid. This was filed about 3 weeks ago, 3 weeks ago. This was June 27th, docket 169. So this is filed public version, reply in support of motion to withdraw as counsel. So Sean Chapman Hawley wants to withdraw as L.A. Reid's counsel. Now, this is also the lawyer who allegedly worked with Lou Taylor to put Lindsay Lohan into a conservatorship, according to Lindsay Lohan's dad, Michael Lohan. Lindsay Lohan's dad, Michael Lohan, has said publicly in the past, I think it was around 2010 or 2011, that Lou Taylor, that's how he said it, worked with Michael Lohan's ex-wife, who would be Lindsay Lohan's mom, Lou Taylor, which is P. Diddy's business manager, also the mastermind behind Britney Spears' conservatorship, according to many people online. Lou Taylor worked with Dina Lohan to put Lindsay Lohan into a conservatorship. And Lindsay Lohan's dad started speaking out about it, okay? He said those two women worked with Sean Chapman Hawley. Sean Chapman Hawley is what he said, and wouldn't let Sean Chapman Hawley wouldn't let Lindsay out, wouldn't let her, all kinds of stuff. Y'all can go look it up in the public record. I'm doing this off the top of my head. Don't take anything I'm saying as fact. It's all from public records. Okay, so I haven't looked at it in a while. But Sean Chapman Hawley does not work for free. So she wants off this L.A. Reid case. She wants out of here. Not only her, but her co-partners, her co-counsel, Gregory Korn, Sue Ann McIsaac, Kate Mangles. L.A. Reid's failure to pay his fees is good cause for the motion to withdraw. He has come up and collected an extraordinary amount of fees that the firm is owed, and the severe impact that non-payment will have on Sean Chapman Hawley's small firm if it is forced to continue defending L.A. Reid. It's like, please, you can't make us keep defending him. The moving papers were supported by the declaration of Sean Chapman Hawley. She attested that L.A. Reid stopped paying his law bills, his legal bills, months ago. He has a substantial balance, particularly given his former counsel already withdrew recently. So one of his lawyers already got out of this thing, L.A. Reid. His last payment that he gave was in February. But see, Drew Dixon's side is trying to say no. Drew Dixon's side is trying to say no, they have to stay on the case. But Sean Chapman Hawley's like, no, I don't want to stay on the case. Make me keep working for free. And she also said that, it's putting a significant financial strain on her law firm and her business. They have to pay experts. They have to pay all these people. She's like, you can't put this on us. He ain't paying. This is not a delay tactic, Your Honor. We can't work for free. We're going to go broke. And she also says, and I think this is a good argument, that a lot of stuff's already done. It's not like a whole lot has to be still left to be done. We've done a lot of stuff for free. We've paid for things. The forensics process is essentially complete. The defense counsel we've spent dozens of hours working with a forensics company, Kroll. They did Britney Spears' stuff, if I remember correctly, Kroll and Associates. Also, the trial is in September, but it's not so close that L.A. Reid is going to be prevented from obtaining counsel to represent him. Excuse me, girl. 3 months? She's saying, trial's in 3 months, but He'll be able to get a lawyer by then, even though he can't pay her. The court held the fact that the opposition to the two, okay, so she's trying to get out of here. She's not trying to do this. So the judge, they had court on this particular issue yesterday. And it looks like the judge is actually going to allow Sean Chapman Hawley to withdraw from this case, but not yet. The judge is going to make them stay on just to be able to close out discovery. And if they don't hear back from either L.A. Reid from the court, if they don't hear at the court back from L.A. Reid or, another lawyer saying, hey, I represent L.A. Reid or whatever, then the judge is considering granting a default judgment against L.A. Reid. And this is so important because it brings in royalties from an Usher song. And I would not have known this if it weren't for National Treasure and National Hero Inner City Press tweeting about it. He was in the court yesterday tweeting about it. I'm looking at his Twitter right now. God, he's always doing something, y'all. Golly, does the man sleep? Hold on, I'm just looking for I'm looking for the Drew Dixon stuff from yesterday, the Inner City Press tweet. I had it up, but then I closed it. So now I'm just scrolling through his Twitter here. I can put it up so y'all can see what I'm looking at. Okay, that was Rubio. Okay, here we go. Drew Dixon versus L.A. Reid. Here we go. This is from yesterday. He said, Drew Dixon versus L.A. Reid. Defense counsel says not getting paid. L.A. mansion can't be sold. Okay, so I don't know what the L.A. mansion can't be sold thing is about. At one point, okay, so this is Sean Chapman Hawley. This is L.A. Reid's lawyer. But she's not like fully really defending him. She's actually defending herself against him right now, even though she's supposed to be representing him. She says, at one point, Mr. Reid, L.A. Reid, changed his phone number, Your Honor, and I couldn't reach him. That's when we became aware of destruction of text messages. Our firm paid for a forensic review. The judge called us generous, Your Honor. The judge says, okay, has Mr. L.A. Reid, the client, spoken to you? Sean Chapman Hawley, his lawyer, has he spoken to you about your motion to withdraw as counsel, as his lawyer? Sean Chapman Hawley said, yeah, and he expressed displeasure. He didn't want her to withdraw as his lawyer, but she's like, I don't work for free. This ain't pro bono, L.A. Reid. So then Drew Dixon's lawyer says, we deposed whoever Mr. Johnson is. The house can be sold. Mariah Carey met at his house in October 2024. Ooh, we're getting a Mariah Carey entering the chat, okay? Why can the house be sold? Something about Mariah Carey met at his house in October 2024. I'm going to look into some documents to see if I can get together what that is, what that means. But Drew Dixon's lawyer is saying we can sell that house and he can pay the default, what we're suing for. If he's not going to bother showing up to court, give us our money. Don't act like you forgot. Then she's not done, or he or she is not done. This lawyer, Drew Dixon's lawyer, says also L.A. Reid could pay from the song Good. Good, the song Good with Usher. The judge said, There may be a pattern of delay tactics on the behalf of by LA Reid. The judge says, but I don't want to hurt this small boutique defense firm. I'm actually considering denying the motion to withdraw so we can just end discovery. But I don't think I'm going to deny the motion for trial. I think I'm going to say Sean Chapman Hawley does not have to represent L.A. Reid for free during trial, but she might have to go ahead and finish doing it just for the discovery period, which is set to end within a month or two. The judge says, I'm going to allow them to withdraw before the trial. So Sean Chapman Hawley is going to get out of it. Look, if Mr. Reid or a new counsel, like a new lawyer or him on behalf of himself, don't show up for the final pretrial conference, then Drew Dixon can move for a default judgment. Okay. So that was yesterday. And it's going to be September 8th. September 8th is the status update hearing. So 2 months LA Reid has to respond to Drew Dixon. This is for the lawsuit with him. That was the third lawsuit we talked about. First one we talked about was Shannon Sharpe. He had a hearing yesterday defending himself. Tony Busby is the lawyer suing him. He didn't bother showing up. Neither did the co-counsel. Then we had the other, and then there's going to be another update next month, August 22nd, and then another one on September 3rd. Now, another interesting snag in the Shannon Sharpe case is he hasn't filed anything in the case, but he did show up, or his lawyers did yesterday for the hearing. Then the second case we talked about was Drew Dixon versus Russell Simmons. That one has an update here. Oral arguments in person, 2 p.m., July 16th. On whether or not the judge going to vacate his previous order or her previous order allowing the lawsuit to be dismissed. Allowing the lawsuit to move forward, denying Russell Simmons' motion to dismiss. He's trying to open that door back open and go back and argue that he missed court. So they're going to go argue about whether or not they can argue about something later. That's coming up. Then the third case we talked about was the L.A. Reid, Drew Dixon versus L.A. Reid case, separate case, but same plaintiff. They have a status update hearing on September 8th. And if L.A. Reid doesn't pay his lawyers or get his stuff together, the judge is going to allow Drew Dixon to move for a default, meaning he's going to have to pay. And they're trying to take his money from the Usher song. They're trying to take his money from the house that Mariah Carey visited in October last year. Okay. So we also have another, let's talk about a fourth case. This is the Kefi D case. Dwayne Keith Davis. This is the person who is standing trial right now, also in Nevada, for the tragic, untimely unaliving of Tupac Shakur. They got a man in custody. His name's Kefi D, or Keith Davis, Dwayne Keith Davis, rather. Kefi D is his nickname, but that's what he goes by. Now, he went all over Art of Dialogue, or was it DJ Vlad, or was it Behavior? Was it this, that? Basically self-snitching. He wrote a book basically self-snitching, and now the government's trying to use the self-snitch against him to make him guilty of unaliving. He's standing trial now. His trial was supposed to originally start this year. It's supposed to be over already. It was supposed to start March this year, but it got pushed back. It's going to actually now be starting in February. So in the meantime, they have been having status update hearings. Now, I don't know if y'all knew this or not. Kefi D, he's been charged and convicted of a whole entire other separate crime, found guilty, since he's been sitting in prison. Yep. He got into it with another inmate and got charged, got put toward a jury trial, and he was found guilty. So now he's got that on his record, on his rap sheet, going into this unaliving trial coming up in February. I didn't know that. I caught up on that yesterday. So he has a status update hearings one day after that Dixon versus LA Reid, Drew Dixon versus LA Reid. So one day later, we got the Keefe D status update. And they have been having cameras in there. So maybe we'll get a little live peek as the Keefe D trial starts to move closer. That's one of the ones that's not in federal court. I have seen some camera evidence, camera coverage of the Keefe D trial. So that one's September 9th. He got a status update hearing for pretrial. Then the very next day, September 10th, we're going to move to the 4th, 5th. I don't know what number we're on. Another case, the Thee Stallion case. This one's one Nicki Minaj was tweeting furiously about over the last few days. The cameraman, remember the cameraman suing Thee Stallion, saying he was forced to watch S acts and all of that. Well, Rock Nation and them tried to get it dismissed. And recently, last couple of days or whatever, the judge said, no, not dismissed. It's going to move forward. And also Desiree Perez, who we've covered briefly, talking about, she's the CEO of Rock Nation, the Demore Hadley situation. Desiree Perez has to sit down and do a deposition. The deposition has to last at least, for 3 hours, the judge said. Now, they tried to make it where she didn't have to get deposed. That wasn't going to cut it. Then they said that 3 hours is too long. Can you just do 2 hours? The judge said no. 3 hours is plenty. She can find time, and it has to happen in the next few weeks or whatever. Well, that case has a status update conference September 10th. All right. So 3 days in a row, 8th, 9th, 10th of September, big days. All right. The 8th, we got the Drew Dixon versus LA Reid status update hearing. And if LA Reid hasn't responded, paid his lawyers and done stuff, I mean, Drew Dixon might win by default, might got Usher's song royalties on the line and everything else. Then the very next day, we got the Keefe D status update hearing before his, for pretrial. And then the very next day on the 10th, we got the Thee Stallion. I think his name is what's his name? Emilio Garcia. Versus the hot girl touring, Thee Stallion, all that. So status conference, September 10th. And then what I have on I still need to add a few cases here. This isn't all of them. I just wanted to go live today about what I was able to come together with so far. This is quite a few cases, but I expect that the schedule is going to fill in even more so. But that's September 10th is the Thee Stallion thing with the status conference. And then October 3rd, also in September is let's say LA Reid is able to find a lawyer and all of that. The trial for the LA Reid one is also in September. So if he's able to get a lawyer, then we're going to be seeing a trial in September with Drew Dixon and LA Reid. It looks like he's not going to have it. It looks like it's probably leaning toward the default. The lawyers are all dropping like flies. They're trying to get off the case. Nobody can get in touch with LA Reid. He's now apparently changed his number. Somebody said he's probably moved to Bali. I wouldn't be surprised. But then moving out of the month of September, moving into the month of October 3rd, as you are probably already aware, Diddy is going to be sentenced. That is the Diddy sentencing hearing. Now, there are dates all sprinkled throughout between right now and October 3rd that are major dates in the Diddy trial. I'm not listing them here. I'm not naming them here. They're not on my list. But Diddy has to do like interviews and, there's a lot of stuff that's happening between now and October. The next month, we have another update, another case. This is what we on 6-7. Abercrombie. Michael Jeffries. So let me pull up the document for this Abercrombie Michael Jeffries case. This guy is accused of very similar. This is a criminal case. Okay. This guy is accused of similar things to what Diddy was accused of. However, I'm not exactly sure. Not much has been going on with this case, y'all. And it's because this guy, Michael Jeffries, the former CEO of Abercrombie. Now, this is interesting too. Y'all remember the Michael Jeffries guy kind of links into the Epstein web. And that's a big thing going on in the news right now. How does Michael Jeffries link into the Epstein web? Good question. It's through Les Wexner. Let me pull up my web and I'll show y'all. Do I have Mike Jeffries on here? No, it's a different web. Hold on. Abercrombie web. I have a whole Abercrombie web, y'all. Here we are. Okay. Here is Mike Jeffries. Okay. Mike Jeffries. This is him in his younger years. Well, now today they're trying to say this guy is mentally incompetent to stand trial. Yes, as you can see, Victoria's Secret is here, Abercrombie and Fitch is here. Why? Because they're all part of L Brands. What is L Brands? It's a company, a fashion company mostly, but it might just be like consumables and stuff at this point. Bath and Body Works, Victoria's Secret Pink, La Senza, it's a bra lingerie company. Also Victoria's Secret, Henri Bendel, I don't know what that is. Abercrombie and Fitch was owned, or maybe still is, by L Brands. And this guy was the CEO. Arrested in S trafficking investigation. This was last year. I did videos on this. I could see if I can bring those up. Surprise witness, Abercrombie. Yeah, here it is right here. Oh, I have 2 videos on that. 3 videos on that. I have a lot of videos on this. Okay. Maybe I should make a little listy list. Hold on. Let me pull this up. So this is a few of them I've made. Ex-Abercrombie CEO incompetent, according to his own lawyer. 2023 Abercrombie lawsuit that started it all gives details. And then the feds swear Diddy and Abercrombie CEO are very different. I think I also made a BJ Investigates on it. So if you just type in like That Surprise Witness, Abercrombie, you can see I've made many videos about this in the past. I think I also, again, made a BJ Investigates about it, and also have an Abercrombie web that I have discussed with y'all in these videos in the past. So let me just bring that back up. This is him. Now, lately in the news, this fella has been coming up quite a bit. All right. He lived in this place. What is this? Who is this? The mansion in New York was gifted to him by Les Wexner. So there was a mansion that was formerly a school. It was given to him by this guy. These guys are commonly associated with each other. These two right here. Les Wexner and Jeffrey Epstein. Okay, so Les Wexner owned L Brands, which owned Abercrombie, which was run by this guy, Mike Jeffries. Okay, so now Mike Jeffries is currently standing trial for S trafficking. And aren't we starting to notice that pattern? Are you starting to notice a pattern? This guy was indicted and allegedly, unalived his own self in jail before, awaiting his trial. But I think he was also found guilty of certain heinous crimes in Florida, but he never really stood any jail time. This guy accused of trafficking, and he's not competent to stand trial. Then this guy right here, let's not forget him, found not guilty. Again, y'all, he's found not guilty. Nothing I can do. But found not. So this guy, and this guy were all accused of the same thing. Interesting. This guy didn't live long enough for trial. This guy not guilty. This guy can't stand trial for a criminal trial because he's too incompetent. So we have an update. to that. And it's a joint letter. It was sent 1 month ago. And let me read it to you. It's a public document, public record. Please don't contact anybody mentioned here. This is just to discuss this filing. This is the Abercrombie guy. This video is supposed to be a what's going on with these cases that I've talked about moment. And there are a few more that I've talked about that are not included in this video, including, for example, the Blake Lively lawsuit and its progeny. That's not included in today's video, but I do plan on revisiting and circling back. Luigi Mangione is not included in today's video. I do plan on circling back. The clock was just ticking and I was going in order of the news that I'd heard of. And the first one, Shannon Sharpe, they had a thing yesterday. The Drew Dixon, LA Reid was yesterday, which then brought me to the Russell Simmons. So I do plan on covering, like doing this kind of roundup of like, what's the most recent thing filed? Where do we stand? What's going on? But I was just running out of time today and also just like starting to see stars. So let me pull up this letter. This is a joint letter. This is in the Abercrombie and Fitch CEO S. Ficking case. This is from June 10th. Today's July 10th. We write on behalf of the parties in the above captioned matter. This is a joint letter from both sides. This is a criminal case. So this is a joint letter from the defense and also the prosecutor. We write on behalf of the parties in the above captioned matter. In response to the court's request for a joint letter regarding the parties' position as to severance of the defendants, Matthew Smith and James Jacobson, on the basis of any delay potentially caused by ongoing competency litigation as to defendant Michael Jeffries. Okay, so who are we working with here? Who is Matthew Smith? Who is James Jacobson? These are the names of the co-defendants. It's 3 of them in this supposed co-conspirators or whatever, okay? Matthew Smith, James Jacobson, and Michael Jeffries. Michael Jeffries is the Abercrombie and Fitch CEO, or former Abercrombie and Fitch CEO. He has not been the CEO in quite some time. But there's co-defendants in this criminal case, and that is Matthew Smith and James Jacobson. Now, the judge is saying, I asked y'all back in May what your thoughts were on separating these 2 cases out, making it into 2 cases. One against Michael Jeffries, because we're just going to sit around here and wait all day. Who knows if he's ever going to be able to be competent to stand trial. But then we got these other guys just sitting around. One of them might be being held in jail or got a bond or something. And they're just sitting around. Their right to a speedy trial might eventually start to become affected. And so for that reason, the judge said, can you get together the 2 different sides in these Abercrombie case and decide what your thoughts are on separating this Michael Jeffries guy out so we can get the show on the road with everybody else? Who knows if this guy might got dementia, he might not ever bounce back. Then what? We got to get these other guys' trial going. Now he asked that, or she, I don't know if the judge is a he or a she. We write on behalf of the parties in the above captioned matter. This is the lawyers writing, both lawyers, the joint letter. Response to your request for a joint letter on our position, whether or not to separate these lawsuits out. As noted in prior joint status letters, and as we discussed in the May conference, they had a hearing in May on this issue. We've produced a lot of discovery to the defendants. We also produced a lot of material under the 3500 statute, the 3500 material. They're presently being reviewed by the defendants. All of these, there's 3 defendants and their lawyers. Although the investigation remains ongoing, the government has produced the majority of the Rule 16 discovery and the 3500 material in its possession. Concurrent to these discovery productions and review, the Abercrombie CEO, or former CEO, filed 2 applications in furtherance of a determination as to his current mental capacity or competency. In May this year, so a couple months ago, the court issued an order granting the second app. So he keeps asking for a delay, this Abercrombie guy. And the judge is like, so far, like, yeah, but can y'all come together and tell me how many more delays I'm going to have to grant? Can we just get the show on the road with the other guys or what? So Jeffries is, look, quote, shall be, and in the law, shall means it's not up for debate. It's going to happen. Shall be committed to the custody of the Attorney General for a period not to exceed 4 months to determine whether his competency may be restored. Okay, so in May, so 2 months ago, the judge granted an order transferring this guy to the custody of the Attorney General for up to 4 months to determine what? What are they trying to determine? Whether Mike Jeffries is ever going to be able to have his competency restored to stand trial or if it needs to be handled in a different way. This is 2 months ago. At the May conference, the feds informed the court that the Bureau of Prisons designated the CEO, Jeffries, to FMC Butner in Butner, North Carolina. Okay, so they're going to transfer him to like a dementia prison facility. The Bureau of Prisons since informed the parties that Jeffries shall surrender to that facility in North Carolina on July 21st, 2025. Now remember, when was this letter written? This was a month ago, June 10th. So a month ago, they were like, look, Your Honor, in like a month and a half, we're going to transfer Mike Jeffries over to this facility in Butner, North Carolina, July 21st, 2025. At that point, there is going to be an assessment done. So this hasn't happened yet. Today's July 10th. So we still got another 17 days, about 2.5 weeks. There's going to be a restoration assessment in North Carolina on Mike Jeffries. Now, if applicable, a process to restore him to his mental capacities is going to begin. Now, what are they doing at this facility in North Carolina that's going to fix his brain enough to stand trial, girl? I mean, your guess is as good as mine. I'm kind of concerned. Is it like, girl, don't get me started. Anyway, at the May 13th conference, counsel for all defendants informed. So all the 3 defendants, that Michael and that, what's their names? Matthew, James, and Michael, their lawyers all told the court that they were still in the process of analyzing the discovery material that they received from the government. Independent of the timeline for a competency determination as to Jeffries, defendant Smith and Jacobson, the other 2 guys, they still already requested additional time, Your Honor. Therefore, the court excluded the time between May and August 2025 in the interest of justice. It will permit all 3 defendants to review. Okay. So basically, they're just putting it on the record so that these guys don't come back later and say, we didn't have enough time. They kept us in jail all this time. We didn't have a speedy trial. This wasn't fair. It's basically, they're just putting it all in writing, saying the procedural history. Neither counsel for these other 2 guys, right? So one guy, the former Abercrombie and Fitch CEO, he's the one that's like, maybe he has dementia, maybe he can't stand trial, maybe he can, et cetera, et cetera. But y'all need to be aware, if he can't stand trial, that doesn't mean he gets to go sit at his house. That's not what that means. There's like other processes that go into play. And it's like sometimes a lot worse than jail because you get held at like a facility forever. And it's like they can drug you there and stuff like that. Like maybe they can do it in jail, but it's not always better, and sometimes it can actually be worse if you can't stand trial, because then you don't actually have a sentence. You just are in like basically purgatory. Like you're not about to walk out and go to your house. Now, maybe he will. That is not how I understand it to be going to work. That being said, there's 2 other guys that don't have dementia, and it's time for them to get the show on the road with them. But the 2 sides, now remember, this is a joint letter. The 2 sides are saying neither counsel for those other 2 guys has made any motion for a speedy trial or a severance. Instead, on the other hand, alternatively, to the contrary, they have actually asserted that they require additional time to review and analyze the discovery. And so in light of that, all the parties agree that to date, this was last month, June 10th, there's been neither delay or prejudice as to Smith and Jacobson. So they're saying, look, we admit it, Your Honor. We need more time. We're not in a rush. Okay. At present, based on the ongoing need to review discovery and the government's substantial and early production of the 3500 material, the Jeffries competency litigation has not created a delay, and nobody from either of the other defendants' side anticipates making a motion for severance. Moreover, although the parties agree that the Bureau of Prisons' determination as to what... So the other two sides are saying, we don't want to do a severance. We want y'all to wait. But not forever, Your Honor. Not forever. The parties agree that the Bureau of Prisons' determination as to whether Mike Jeffries' competency can be so-called restored, it will directly, so the determination on his competency is going to directly impact the outcome of the case as to that one defendant and the timing of the trial. And they're like, everybody, at all the parties, we all agree and we all anticipate that the court and the parties will have substantially more information in the coming months. Why? Because he is about to have this assessment. The assessment is going to start in 2 weeks. So they're basically kicking the can down the road. They want him to have his mental competency assessment. And what is the assessment going to determine? Not only is he competent right now to stand trial, yes or no. That's not what it's going to determine. What it is going to determine is whether he has the capacity to be restored to ever reach the place where he can stand trial. Again, I have no idea how they're going to run that assessment, but they're going to send him off over there to Butner, North Carolina, to the FMS Butler or whatever it's called. And they're going to run this assessment with these specialized doctors or specialized specialists who are going to determine, who are going to say whether or not this guy, Mike Jeffries, the main guy that we've all heard of, the Abercrombie CEO, whether he's even able to be restored to competency or not. Now, if he's not, I mean, there's going to be other issues for him, like conservatorship down the pipeline and stuff. But at that point, the judge may determine this is a totally separate trial between Mike Jeffries and these other two guys, because there's all these other considerations. He's not of the right sound mind. Again, this does not mean that he gets off. A lot of people get so emotional and worked up, like, why does he get to get off? Stop the madness. He doesn't just walk out of the front freaking door. I can promise you that. The same way he's not able to walk out the front door right now. He's sitting over there at the MDC or wherever he is. That's how it's going to be. So don't worry. Let me pull this back up. More information is going to become available. We will have substantially more information, if not a final assessment, in the coming months about his competency. And then once we have that, then the defendants can decide if they want to move forward separately from Mike Jeffries. And the parties in the court can more accurately assess the duration of the trial as well. Then we can have idea how long the trial is going to actually be, and have a realistic date on which the trial can proceed. They haven't even started to make trial dates yet. Now, this man was arrested 1 month after Diddy. Diddy's already had his trial and been sentenced, or excuse me, hasn't been sentenced, has been rendered a verdict. All right. He was arrested. Diddy was arrested September. Mike Jeffries was arrested, I believe it was October, if I recall correctly. So it's just been getting pushed down the road, and the can been getting pushed down and kicked down the road. But both defendants that are co-defendants with this Mike Jeffries guy are like, we're chilling. We are chilling. Let this guy get his competency. We'll make a decision after that. But we chilling right now, Your Honor. We're good. We're not going to come back and try to appeal this. No, we're not. So based on the above, it is the party's position that it will likely be appropriate to continue to exclude time at least through November. Okay, so they're saying we thinking it's at least going to be November. Just give us a couple more months. Although the government and the public has a strong interest in the timely resolution of this matter, the interests that they have are outweighed by the need for efficiency. Because basically, if they could have the trial where it's all them together, that would be most efficient. So they're going to try and, do that if possible. So what else do we have as an update on this? Oh, okay. And then that brings us, so that's November, the Jeffries, that isn't the trial. That's just like, oh, okay, we can move forward. Like the Speedy Trial Act time can be moved. So I just wanted to update y'all on that, where that case stands. They did have a hearing last month. The guy, they're saying he can't stand trial. And so they're trying to see if he's ever going to be able to stand trial, yes or no. There's in about 2 weeks, he's going to be transferred. This Abercrombie former CEO, he's going to be transferred to a facility in North Carolina to undergo an assessment. Maybe by November, they might be ready to do some movements. Okay. And then February is when the Kefi D trial starts. Tina, anything on Wendy? Let me write Wendy down. Let me see. So who was it? Okay. So Wendy, Luigi. What were the other ones that I was like, oh, Blake Lively and Baldoni? Tyler Perry. Yep, Tyler Perry. Fat Joe. And there's 2 Tyler Perrys, but I only covered one so far. I know it's so many cases right now. I know. Rhymir and Jay-Z. Okay, Shantae, thank you for asking this because there were a lot of, oh yeah, Mars said Megan Thee Stallion. Let me write her. Yep, Megan. And there's 2 with Megan, right? Or just one? Oh, and Demore, hers too. Oh my God, so many cases, y'all. See, this Ashley, where? Which case? Because when I was looking it up, I didn't see that. There's been like a lot of reporting that like Rhymir's case got the green light to move forward. And the judge ordered a DNA sample. And I have looked high and low. Is it, I'm missing it? Is it like in New Jersey State Court or something? Is it in Pennsylvania State Court? Is it, where is that lawsuit where he's been granted permission? I'm logging into Pacer right now because I'm going to look up his last name or his full name. Okay, look. It's right here. It's the only case open. The other ones have all closed. So it certainly can't be those. And then look, the most recent thing. This is, look, it's, oh shoot. Let me not show people's addresses. I didn't know that was on there. Pro Se versus Sean Cooley Carter. Complaint, certification application, clerical error. Okay, let me show. I can bring it back up now. Declaration of attempted service. So this is Rhymir saying, I'm trying to serve Jay-Z, but I can't. And then Jay-Z last month, about a month ago, files a declaration and an ex parte application to extend the time to answer. This is the Rhymir case. Since we're here, I'll just update on this one too. Initial standing order the judge gave. So then there's a judge's order here about 3 weeks ago, or maybe even more now, about 3 weeks ago, but less than a month ago, an order from the judge granting Jay-Z additional time to respond. This is due July 18th. Okay, so maybe that's what they're talking about. Notice of related case. The related case Okay, hold on. Let me look at this. This is from June 24th. Let me just look at it first before I don't want to show anyone's address on accident. Sherry Peace Garnett, order regarded transfer to related. Okay, so related case with what? That Lily Cooley one was, okay, I guess maybe the Lily Cooley is like, oh man, put back in with this. Let's see, hold on. But Rhymir is opposing it. He's saying this is not a related case. But you see how I'm saying, like, none of this is saying the judge granted something. This is Rhymir's filing. He respectfully requests that the court deny any notice to consolidate this case with Lily Cooley's. He's a totally separate action from Miss Coley. Coley, not Cooley, sorry. Rhymir has an inheritance case. These cases were litigated in two separate forums, two different document numbers along with different laws and facts. Rhymir's lawsuit is not being brought to relitigate any domestic relations matters. He brought this action to assert personal claims for injuries resulting from the unlawful conduct described herein. Both of these cases do have a common defendant and involve allegations of fraud upon the courts. The specific legal harms, legal standing, and the relief are entirely distinct. This is Rhymir's filing. Rhymir is saying my case focuses primarily on inheritance rights and identity-based emotional distress stemming from suppression of paternity claims. In contrast, Miss Lily Coley's case centers on direct financial devastation through fraudulent liens placed on her personal property. Okay, all right. Loss of her home sale, and I did go over this before I read this lawsuit. These divergent legal theories and factual predicates would create confusion rather than clarity, prejudice rather than efficiency, and complexity rather than a streamlined or efficient resolution. Okay, so I see what he's arguing. However, where is the thing about the judge is going to allow it to move forward? Maybe it's this. He granted the thing is due by July 18th. Is that maybe this what they talking about? Ashley and the rest of the cousins? On June 16th. Yeah, I guess he does have to. Okay, maybe this is what they're talking about. So let me save this. So I don't have to buy it again. I did a get ready with me this morning. If you ever wondered what I look like underneath the makeup. Okay. And I turned the filter off. Shout out to y'all who were in there. It was very early this morning. This is Rhymir. This was 6:20. So about 3 weeks ago, the judge did say, you got to respond. 14 order granting Jay-Z motion extended time. Let me pull that document up and I really want to inspect it. Okay. Here we go. This is the Rhymir. Oh man, I lost it. Hold on. Gotta go through all these layers. Here it is. All right, here we go. This is one of the most recently filed documents, but it's the most recent order other than that standing order. Granting defendant's ex parte application. This is an order. Granting Jay-Z, Sean Corey Carter. He applied for extra time, additional time. Granted. Okay, the court granted it. On June 16th, last month, he filed an application for additional time. The court reviewed and considered the application and found good cause and grants Jay-Z's request. Now he has until July 18th. So let me put that in my little coming up calendar. July 18th. That's going to be Jay-Z deadline to respond to Rhymir complaint. Now, what is this Rhymir complaint? Do y'all want to read through it right now, or are y'all tired? Are y'all tired? Hunter Gibson, I don't know what's happening with Nicki Minaj other than what she's been tweeting. I don't think there's any court unless somebody just found out about a court lawsuit going on. Put a yes in the chat if I should go over. Okay, y'all are saying yeah. Okay. All right, that's okay. Then let me go over there and do that. All right, let's go to back to Pacer. Let's look at this one. This is document number 10. This is the Jay-Z request. So let me download this one. Docket number 10. Yeah, docket number 10. It's 8 pages. Again, I do have to, download it and save it because every time I go in, I got to repurchase it. It's aggravating. Okay, Rhymir. It's expensive. 2025. When was this filed? June 16th. And this is docket 10 in the Rhymir case. Rhymir versus Jay-Z. This is Jay-Z motion extra time. It's 8 pages long. So let me pull that up and we can read that. And we're kind of like going in reverse. We're reverse engineering. And then eventually after this one, we'll get to the original complaint. But I think I already did cover that lawsuit. But we can definitely do a recap. Okay, here we go. This is the document. Let me make sure I redact it. Because I don't feel like getting into it with Reid freaking Smith. No, I don't. Do not contact anybody mentioned in this video. This video is to report and discuss opinions and reactions to a high-profile public lawsuit. Yep, I knew he was going to do that. Let me cover this up. And let me cover this up. This is a new way they've been trying to get people, is they will put their own addresses publicly in a document that's public. Then if a YouTuber or content creator were to say, I don't know, read that lawsuit publicly, then they try to get your channel took down and say you were doxing them and exposing them and this thing and that thing. And it's a new thing they're doing. It's new. All right. So I'm not going to fall for that okie doke. Nope. Not me. Pick on somebody else. It ain't about to be me. All right. So this was filed on the 16th of last month. Ex parte application. This is Jay-Z's ex parte application for what? Additional time to plead or otherwise respond to Rhymir's complaint. He also gives memo and support. So he says, we want an order extending the deadline to July 18th, and that's just in about 8 days. Defendant Jay-Z is an internationally known musical artist and businessman whose hard-earned success brand of products is recognized worldwide. This lawsuit and the related lawsuit filed by Lily Coley, we've read that one before. We've read, I think, more than one before, are just the latest events in plaintiff Rhymir Satterthwaite's and his caregiver, Miss Coley's decades-long harassment of Jay-Z. The fabricated allegations and claims have already been addressed, Your Honor. This is what Jay-Z and them are saying. And rejected. So it's already been fought through, Your Honor. This is straight up harassment of Jay-Z and disregard of those previous court orders. And he's already been held in contempt before, Your Honor, says Jay-Z about Rhymir. As detailed here, the complaint was not properly served, and Jay-Z did not learn of the lawsuit until June 3rd, 2025, okay? Did not learn of the lawsuit until last month, Jay-Z claims. He promptly retained counsel who attempted to confer with Rhymir for an extension. Rhymir and Miss Lily Coley refused to respond, which necessitated this ex parte application. When the defense counsel successfully got Lily Coley, so when Jay-Z's lawyer got Lily Coley on the phone and attempted to discuss the matter, including an extension of time, she refused and yelled, "Do not call me at this number." However, this is a phone number provided on the court docket. Then Lily Coley allegedly hung up on the lawyer. Notice of this ex parte application was provided on June 13th to them, the two plaintiffs, and in those two cases, by these addresses and these phone numbers. This ex parte application is based on this notice, memorandum of points of authorities. Okay, let's keep going. Let me just make sure there's no more addresses here. Okay. Here's his memo. And this is Jay-Z's arguments. Reasonable litigation deadline extensions should not require court intervention, but the plaintiff has refused to engage with Jay-Z's lawyers, and therefore it's necessary for me to ask the court to intervene. With this ex parte application, Jay-Z seeks an additional amount of time. So look, he seeks additional time until July 18th to evaluate the complaint and determine how to respond or otherwise plead in response to the complaint. So this was filed on the 16th. This was filed on June 16th, and the due date was supposed to be June 20th. but he didn't file earlier. He waited until 4 days before the deadline to ask the judge for a whole month extension of time. And why did he want an extension of time? He wanted to evaluate the complaint and determine how to respond. Jay-Z's request for additional time is consistent with the local rule and the Central District's civility and professionalism guidelines, and the court should grant Jay-Z's application and order the deadline to respond, give him a time extension until July 18th, which was ultimately granted, as we know, but we're now reading what Jay-Z's arguments were. He says the complaint was filed on May 6th, 2025. It was not served properly. Plaintiff filed a, quote, proof of service on May 29th with this court. While the, quote, proof of service states that service was completed May 23rd, 2025, the accompanying records that Rhymir provides confirm that Rhymir failed to comply with the requirements to effectuate. So basically, Jay-Z and them are saying, he's trying to say that he properly served, but he didn't. He didn't follow all the rules, Your Honor. And so I didn't even get proper service. I didn't learn about this lawsuit till June 3rd, last month. Without waiving his right to challenge certain deficiencies, but recognizing proof of service was filed, defense counsel sought plaintiff's consent to a stipulation to extend the time, but the plaintiff, Rhymir, is unwilling to engage by email or phone. Jay-Z seeks additional time to evaluate how to respond. So what does he want this additional time for? To evaluate how to respond. Why don't he respond with just doing a paternity test? Okay, Jay-Z says the complaint consists of fabricated and fanciful allegations that at bottom take issue with orders already entered against Rhymir and Miss Coley in other courts. Dissatisfied with the results from other courts, Your Honor, Rhymir and Lily Coley now try to engage in forum shopping. Forum shopping is where it's like, you try to go to the court where you think you're going to have the most likelihood to win. To assert the same previously rejected positions and ask this court to declare all judgments, liens, and sealing orders are null and void and unenforceable. Even if service was proper, Your Honor, this is Jay-Z still talking, or his side rather. Jay-Z's side says Rhymir's demand in this lawsuit raised multiple legal bars to the claims that Rhymir is trying to bring toward Jay-Z, including pursuant to the Rooker-Feldman doctrine, res judicata, and the California anti-SLAPP statute. I love the California anti-SLAPP statute, personally. A short continuance Jay-Z is asking for. Why is this relief appropriate? He'll be prejudiced. Whatever. Okay, so we know that Jay-Z was eventually Carla Wirtschafter is Jay-Z's lawyer. Okay, so we know that this was granted. And I already did read this lawsuit on a video before, so I'm not going to get into reading the lawsuit right now. But the judge, I think that the reason why people are saying the judge ordered that it can go forward is because the judge is requiring Jay-Z to respond to the lawsuit. The judge is requiring. However, Jay-Z is still and could still be successful in getting this pretty much kicked off, dismissed, and not argued, because what Jay-Z was asking for was just more time to respond. Now, when he does finally respond, I would not be surprised if he were to respond by saying, I am not subject to the jurisdiction of this court. I am not subject because of the collateral estoppel and res judicata. These issues have already been determined. This court doesn't have jurisdiction because another related case already exists and they should be consolidated. I mean, I expect that all of those arguments will be made by Jay-Z, and then some I can't even think of. Thanks so much, Oklahoma Outlaw Audits, for gifting a membership. Thank you, Bailey, for the $9.99 super chat. Adore you. Thank you. Thank you. Thank you, Virginia, for the $5 super sticker. Thank you, Mushroom, for becoming a member. Shout out to you. Thank you, Cherry Cupcake, for the $2 pound super chat. Maybe they want to check that Jeffries isn't lying. Maybe that's possible. Thanks so much for the £2. Thinking you like playing for the $4.99. I don't know what we're talking about, but your make still rocking it. Thank you so much for that $4.99. Yeah, I've already read the lawsuit. Swim Blue Water said Jay-Z this is opinion, I don't know, I'm just reading the comment here, trying to buy time and move assets so Rhymir can't have anything. What a coward. Oh wow, I really hope that's not true. I'm reading some of y'all's comments here. No, yeah. I mean, I even before you can even comment in my chat, just so y'all know, you have to agree to like certain rules. And one of the rules is like I will not contact and send hate. So like literally anybody who's commented on my live chats, like if they're going and sending hate to someone, they're like directly violating a promise they literally made. So I always say and truly mean do not contact anybody or send any hate to anybody that I mention in my videos. I really mean it. Anyone who is doing that is like directly violating what I've asked and demanded. So I can't do anything else other than that. And if somebody is harassing, stalking, doing anything like that, they should be arrested and go to jail. Anybody saying they're doing that on my behalf, no, they're freaking not, because I tell y'all all the time, do not send hate, do not contact, do not even send. I say don't even send a nice message. I mean, I know that is extreme, but I say don't send nothing. Don't send anything. Lucas says, what's my take on this? I don't really know. Shout out to Anthony Frazier. I don't really know, Lucas. I don't have a strong argument one way or the other. I do see what Rhymir is saying. He's saying like this isn't a paternity outcome. This is like because Jay-Z this is an inheritance case. Like I have a control. I don't know. I don't really know. Like obviously I don't really know what I'm talking about. So I would say I really don't have a strong opinion one way or the other or take at this moment. I will say they look uncannily similar. They look a lot alike. But people can look alike and they can't, not be father son. So I would need to see any evidence, that would come up. No hate needs to be thrown because truth prevails always. Yes, indeed. I really mean it. Shout out to Tina Bailey becoming a new member. Yeah, we don't know any of these people. I don't know them. I certainly don't. I wasn't there. I didn't do the DNA test. I can promise you that. Shout out to Callie. Says a little late, but better late than never. So have y'all heard of any other news? Is there any other news I need to talk about? Any other breaking incidents? Let's see. Diddy trial. Nothing really going on with that lately, right? Attorney for Shannon Sharpe's accuser, no show in court yesterday. And it was Busby. Shout out to Virginia for gifting a membership. Jim said, I tagged you on Twitter. What is it? Make sure to tag That Surprise Witness. Okay, got it. In the matter of Coley versus Carter. Okay. Diddy Docket tweeted this. I'm not going to pull it up because I don't want to put anyone's accidentally put an address up or something. But a month ago, Lily Coley moved for default judgment after Jay-Z missed the reply deadline. He got an extension and he must reply by July 18th. It's not Coley, though. It's Satterthwaite, I thought. He believes service was improper. He is appearing in this action in an abundance of caution. So he has to reply back on July 18th for both of them, did he, docket? Oh, there's a class action lawsuit. What's the class action lawsuit? Let me see. I think that's pretty much. Oh, okay. This is cool. Diddy docket. Whoa, look at this. Oh my gosh. So this is diddydocket.com. This is cool. This is a Diddy update. Federal sentencing calculator. Transportation to engage in institution and related offenses. This calculator estimates federal sentencing guideline based on the 2024 Sentencing Guidelines Manual. Results are for entertainment purposes and speculation purposes only. Should not be considered legal advice, of course. So there's 2 counts of violation of the Mann Act, 2 victims. So, okay, so these are this is cool. So, okay, if the judge wants to use these as special sentencing guidelines, like let's just go like full, let's just check every box just to see the max that we're working with, and then we'll go and check no boxes and see the minimum. Aggravating role, defendant's role in the criminal activity, we'll call him leader. I just want to go every single one. Acceptance of responsibility, no acceptance. Criminal history is 0. Already served 10 months. I don't think we'll go upward departure or downward departure. Woo, Lord. So that would put him at, so if he ends up being an offense level, and I'm not saying he's going to get all that. I just wanted to see, like, if they throw the book at him. Obstruction of justice, everything. If the judge counts all that, which he won't. He's gonna do a split the baby, which he always does. But I just wanted to, what's 240 months? 20 years. Okay, he's not gonna go for 20 years. But we did know that 20 years was the maximum he was facing. Oh, this is cool too. Look at this chart. This is diddydocket.com. This is a free resource. Offense level 41 is what it was like off the chart. Okay, so let's go back through and let's do another calculation. Let's just do a smattering. Okay, let's say, how many victims is 2? Was it for a commercial purpose? Did it involve commercial advantage or private financial gain? I'm going to say no. I think it's fair to say no on this one, because unless you want to count that $20,000 that Diddy got back from, unless you want to, and this is all speculation for, educational purposes. I did not make this chart. I did not make this calculator. I'm just playing with it. I'm playing around with it. It's dailydocket.com. Y'all can go play with it yourself too. But for me, I'm going to try to go reasonable middle of the road here. I'm going to try to be middle of the road as I can here. I don't think that it was proven that Diddy was making private financial gain. He was getting private gain, but this is specific categories. Okay. Did it involve interstate or international? Plus 2 levels. The offense involved crossing state or national boundaries? Yes. I'm going to say yes on that. Victim under 18? No. No, that was not alleged. That was not charged. So it certainly wasn't proven. So we cannot fill that one in. Okay. Use of a computer or the internet. Yeah, they were on Cowboy and Angel. This is just my opinion, y'all. This is just a tool. It's just a little, you can go and do your own one. Did it involve fraud or coercion? Did it involve fraud or coercion? Is the judge going to find that it involved fraud or coercion? I'm trying to go middle of the road, what I think the judge is going to do. I think he would. I'm going to go yes. Was the victim particularly vulnerable due to other factors? And I think, yes, under this specific Bail Reform Act, because Cassie was employed by, there was an employer-employee relationship, it adds 2 levels. However, official victim was the victim a government official, a law enforcement officer, or other protected person? I'm going to say no. To my memory off the top of my head, I don't think the government was able to fully prove that enough to where the judge is going to hold it against Diddy. But I do think the victim, Cassie specifically, was vulnerable in particular because she was his employee, and he had the 10 album deal, and it was basically her whole career, if she ever wanted to be a singer, was in his hands. And I think under the Bail Reform Act, from what I read, that counts as a vulnerable victim if you man act your employee. But I'm not sure about this official victim. Now, some people who weren't trying to be down the middle might find a way to click yes on this one. I'm just trying to see what I think the judge is going to reasonably most likely do, based on my guess of what he would do, based on what few things I've seen him do in the past. That's all this is. Okay, so what about the aggravating role adjustment? I'm going to go, he was an organizer or leader of the transportation. If I said trafficking earlier on accident, it wasn't trafficking. I did have said many times throughout this 2-hour video that he was found not guilty on that. But just to reiterate, I don't know if I actually did say that on accident or not. This is just a live stream. All that disclaimer. But I think that the feds were able to prove that this man act activity, which is just like straight up like, pandering, like, actually, I don't know exactly what pandering means, so I shouldn't even say that, but straight up like buying statutes, right? Like paying statutes for stitution acts. Like that's the crime that he's been found guilty of on 2 counts. And I do believe he was an organizer or leader that involved 5 or more participants or was otherwise extensive. I think, yes, I think that was proven. There's 2 counts of it. First of all, that's 2 people just right off the bat. Was it extensive? Yes. Did it involve 5 or more people? Well, I mean, we had Cabral, aka Sly. We had a Jonathan Oddie, who we heard about. Who else? Daniel Phillip, he testified. We had Italiano. Who else testified? The freak off guy. We had Clayton Howard, who was gonna testify, but then ended up not testifying. We had I mean, that's 5 right there. I'm blanking off the top of my head, but we have, Cassie, we have Jane. Those are found to be. Then Diddy himself, I don't know if he was one of them or not, but I mean, you maybe could count him. We got Cabral, Sly, we got The Punisher, we got Italiano, we got Jonathan Oddie. Those 2 didn't testify. So I think, it's been Daniel Phillip. So Jane, Cassie, Daniel Phillip, Sly Cabral, and The Punisher. There's 5. Okay, so I think that he's the leader. It was for him. Could it have been for somebody else too? Yeah, maybe. But we'll worry about their sentence when they get sentenced. You know what I mean? We talking about Sean P. Diddy Combs right now. Okay. So what about the obstruction of justice? This one I think the judge may find to go both ways. However, based on what the judge did say in his bail deliberations, like he doesn't seem to be too happy with the violence alleged at trial. So it could go up or minus 2 levels. I think he's going to accept responsibility. So I'm going to go -2 levels. Qualifies for 2 reduction and assisted authorities investigation. Did he assist authorities in the investigation? No, the judge is not going to find that, in my opinion. Did he assist the prosecution by timely notifying? No, no. That he's not going to get that one. So I'm not really sure if the judge is going to find obstruction or not. I'll just go no acceptance of responsibility. These 2 I'm having a trouble with knowing what to do. It's like plus or minus 2 levels, but it ends up being plus or minus 4 levels because it's 2 of them that are worth 2. Criminal history is 0. Months already served is 10. Well, by that time, it's going to be more than 10, right? Because it'll be 13 by that point. Why won't it let me? Okay. Because it'll be in October. Based on cooperation? No. Based on violence, uncharged conduct, or multiple victims. Oh, this is going to go. This is where the judge is going to have a lot of, this is where the judge is going to have a lot of sentencing power. Let's just go. Like if the judge finds that there was violence or other uncharged conduct, like the pew-pews, that wasn't charged conduct, but there was proof that he had them in his house somewhere or in his guest house or whatever. The violence the judge saw, that wasn't, remember? He's not charged with domestic violence. All that could lift up the sentencing. Just like I was trying to tell those women outside on the terrace of the 8th floor of the courthouse, the Patrick Moynihan courthouse. I was trying to tell them the judge could take this into consideration. They were screaming at me, no, he was found innocent. Okay, no, first of all, he wasn't. He was found not guilty on RICO. But there's other uncharged conduct that the judge can take into consideration, and he can adjust this sentencing level 2 levels, 3 levels, 4, or 6. And all of these categories count. Violence. Did the judge see evidence of violence? Yes. And it wasn't charged conduct. Other uncharged conduct. Was he charged with arson? No. Was he charged with kidnap? No. Can the judge find there was arson and kidnap and sentence him to longer in jail? Yeah. So let's just go in the middle, 3 levels, because he could go up to 6. There's another one too, multiple victims. They are under the Mann Act calling Cassie and Jane victims, and he was found guilty on these 2. I didn't make the Mann Act up. I didn't make the Bail Reform Act up. I have actually a lot of criticisms about it. I'm just trying to tell y'all what to expect based on what I am speculating. Okay, you don't have to listen to me. You don't have to take my word for it. I, do have a history of being right, but I don't know. Obviously don't know what's going to happen. This is not legal advice. So let's just go with that. I'm going to go significant departure because there is violence, there was some uncharged conduct, and there was multiple victims. What would did he cooperate? No. Does he have family ties? Yeah, maybe we should. Yeah, he has a lot of family, so we can give him down 2 levels on that. Because this is what the judge has been doing. He's been giving a little to the prosecutor, a little to the Diddy, a little to the Diddy, a little to the prosecutor. So we'll go significant departure because there's violence, there's uncharged conduct, and multiple victims, allegedly. Just pretending that I'm the judge here. Y'all can go do this yourself on diddydocket.com. And then I'll say he has a lot of family, got 11 kids, he's gonna have grandkids. The judge might take that into consideration. Let's calculate now. Okay. So this is offense level 29 based on what just my best guesses of what the judge might do. So 109. That's a lot. Hold on. That is 7.25 to 108 7.25. Okay, hold on. 108. I told y'all I can't do division. 9 years. Okay. So based on the calculations that I just guessed, Diddy would be in jail for 7 to 9 years. That's a lot longer than what I had originally thought. He served 13 months, so then he would still have 6 to 8 years left. Base offense level 14. Multiple victims adds 2. Use of computer adds 2. Cross state line adds 2. I think these are fair. I think, Cassie, Jane, that's 2. He used the computer and the internet to find the escorts. I think that's That's very fair. That's obvious. Crossed state lines, yes. Crossed national, yes. Went to Turks and Caicos, went to wherever they were going, Barcelona, wherever they were going, Jamaica. Fraud or coercion. That one the judge might find, might not find. That one I just guessed. I don't know if the judge will find or not. And that's a huge category level. That's 4. That's one of the larger ones. So plus or minus 4, depending on if you think the judge is going to find it. The reason I guessed he would find it is because of the specific relationship between Cassie and Diddy, but that might already be taken care of on the vulnerable victim aspect of things. Was he the leader or was he an organizer? That is a 4 or 2 point thing. And, the judge is going to either find 2 or 4. So if I was being even more conservative, maybe I would do 2, instead of 4. So this is plus or minus 6 levels already. And I was just guessing. Did he accept responsibility, like insofar as like, is he going to actually say, I'm so sorry, I'm never going to do it again. I've gone to the rehab program. I've gone to the batterer program. Like, yeah, I think he's going to at least do that. So he'll get, and he should get some type of credit for doing that stuff, I guess. But moderate credit, not like a whole bunch, in my opinion. And then because there were multiple victims, because there were, allegations of like a bunch of these guys flying in, it happened extensively, overtly. I just did the middle of the road one. I didn't go all the way full substantial, but I didn't do 0 either because the judge did seem to care a lot about the violence. And then he has family ties, so I took off 2 levels because he would have been like a 31. So then that puts us down here, which is still a pretty high up offense level. But then again, like the other one was 41, so I guess it's not that much. So, yeah, I mean, that's like 7 to 9 years. Okay. Thanks so much, TGF, for the $5 Canadian. Was there a conclusion in the case where Lima's lawyers sued her for lawyers' fees? Not to my knowledge. I haven't really been over there checking for her, though. Who was the other party who was being Wonderland Studios or something like that? But I think he dropped them off of there. I don't think he's actually suing them. Now that he's like going after just the attorney fees, I think he might just be only going after her. But again, I haven't really looked. I really don't know. Thank you for that $5 Canadian. I'll take 5 to 7 cuz Angel Clement Guidry said. Shout out to you, member, for 2 months. Yeah, the Punisher. Yeah, some of it'll probably also be probation. I don't think he'll get that long. So maybe on some of those things that I was like, picking a little higher, even the judge will even go a little lower. Maybe the judge won't find force, fraud, coercion. That will lower it down 4 levels. Maybe the judge will only find the special victim category of employee, employer in 1 category. That would probably take down 2 to 4 more. So that takes off a substantial amount. Thanks so much, NT. Are you supposed to link again, BJ, please? I don't know which one. You mean? Okay, well, I guess that's all I'm really gonna have for this one then. I'll come back over here another time, another day, maybe tomorrow, maybe even tomorrow, to read some more updates like this. Let me know if y'all like this type of video where, I'm just like kind of going through a bunch of lawsuits that we've covered just to kind of get the quick of like what's going on, the lowdown. And thank you. Shout out to everyone who has left a super chat. Make sure you didn't get unsubscribed and make sure you go to ThatSurpriseWitness.com to get the last remaining of the limited edition merch. And who knows, what's going to be coming next. So that's all I really had for today. In the meantime, facts ain't defamation, neither are opinions, girl. Love you, mean it. Okay, bye.